Does everyone in Florida need a will? The answer to that question is, if we're taking it quite literally, is no. Not everyone in Florida needs a will. The types of Floridians who don't need a will are going to be those who are willing to take some risk and have limited assets. What do I mean by that? If you have a bank account and that's all you have, you can name a pay-on-death beneficiary, and after you pass away, that person will get whatever's left in your bank account, and whatever, it doesn't matter if there's a will or not, you don't have to go to court to get access to that money, and that's fine. Same thing with if you just have like a 401k, right? If you have your bank account in a 401k or an IRA or brokerage account, these financial accounts always allow you to name a pay-on-death beneficiary, and those assets will go to that person, and there will be no need for a probate and no need for a will. However, you are taking on some risk by doing that, because if the person who you wish to inherit from these financial accounts have predeceased you, or they shouldn't be receiving money because they are on a needs-based government program like SSI or Medicaid, then going to court might be necessary. Because the banks and the financial institutions can only go so deep, meaning if the pay-on-death beneficiaries are not alive, you're going back to court. And in that case, you will want a will, or better yet, you want a revocable trust to avoid having to go to court in the first place. There's another asset that doesn't necessarily require a will, which is your house or real estate. In Florida, we have a concept called a ladybird deed, or you can put a house in a trust. And either way, the real estate will pass to whoever the deed says the house should go to. And same thing with the revocable living trust. So there are people who just may own a home and may have a bank account, and they may, if they are okay with the risk that the person who's supposed to inherit doesn't predecease them, then those people in fact don't need a will. However, we of course encourage everybody to have a will, because whether you have a trust or whether you only have these very limited assets, because the will give the judge, the probate court, instruction on who receives your property should the pay-on-death beneficiary not survive you, right? So it provides for these multiple contingencies. And better yet, you don't want to rely on your will at all in the first place. You want to rely on a trust, because the trust can help you avoid having to go to probate court, or avoid your loved ones having to go to probate court, and get your assets to where you want it to go, and provide for these multiple contingencies. If so-and-so has predeceased you, then what happens with their share? Maybe it goes to their children, maybe it goes to somebody else. Having a will and a revocable living trust allows you to remain in control of where things go. If you don't have a will, if you don't have a trust, and the people who you want to initially get this property pass away before you, now you're relying on the state and a judge we have what's called intestate laws. Or if you don't have a will, there's an order of people who are entitled to your stuff. If you haven't indicated otherwise through a will or a revocable living trust, and maybe that means assets don't go to where you want it to go. So again, that's what estate planning really is all about. It's empowering you to make sure that A, the people who you want to make decisions for you, if you're not able to make decisions, are able to do so. You get to choose, not a judge. And also, who gets your stuff? What's the most efficient way to get your assets to the people you want to inherit from you after your passing? I hope that clears it up. I know I threw a lot of information at you. If you were anywhere in Florida and you want to talk about Medicaid planning, estate planning, probate avoidance, please give us a call, schedule a consultation. Thank you very much.